Welcome to today's bootcamp, where we'll focus our training on dispute resolution part 1. Here, our exercises will strengthen our ability to dispute bills denied for compensability, extent of injury, relatedness, or liability, which we like to use the acronym CERL. And we have a part 2 for this type of dispute. Today, we're going to go over day 5 of our second series bootcamp. We have conquered the ropes course of this camp, and now we are headed to the unstable bridge. With each step, we'll work on our stability to know when an insurance carrier is liable to pay for medical services, understand what the carrier's denial for compensability means, and know how to pursue dispute resolution and what form to use. Before we start, I would like to tell you about our disclaimer. The information in today's presentation is for educational purposes only and is updated as of today, June 23rd, 2026. We want to educate our system participants, but ultimately, it is your responsibility as a system participant to know and comply with the Texas Insurance Code, the Texas Administrative Code, and the Texas Labor Code. This is part 1 for dispute resolution when denials are for CERL, which is compensability, extent of injury, relatedness, or liability. Here's an overview of the topics we'll discuss today. First, we'll talk about the definition of compensability, which is important because compensability tells us what's being accepted or covered for workers' compensation. Then we'll talk about the notice of injury, which is how the injury gets reported, and the notice of denial, which is when the carrier disputes or denies something after their investigation. Some of these types of denials are unavoidable due to the nature of the work-related injury and the medical diagnosing, but we'll discuss how you may be able to avoid some of these denials. Next, we'll discuss identifying if the denial is due to compensability, extent of injury, relatedness, or liability. We'll talk about the next steps to take if you get a bill denied and the dispute paths. And lastly, we'll talk about some resources that the division has available for you. So what is compensable injury? A compensable injury is an injury or illness that occurred during the course and scope of employment. Now you may be wondering, what does course and scope mean? Well, it means the employee is doing something the employer requires them to do to furtherance the affairs of the business. This can be either on work premises or at any other location. Again, as long as the employee is conducting business required per the employer. And this is important to understand because workers' compensation carriers are only liable to pay for medically necessary care for a compensable injury or illness. So if this criteria is met, then it's likely for the carrier to deny the bill due to compensability. The carriers must conduct their investigation of the claim, and they may dispute the compensability of the injury, the extent of the compensable injury, relatedness of the services, or liability of the injury. These are benefit disputes, and we refer to them as CERL disputes, the acronym for compensability, extent, relatedness, or liability. Now, there are times that even if the employee was injured at the job, the carrier may not be liable. There are 6 exceptions where the carrier is not liable, and they can be found in section 406.032 of the Texas Labor Code. Some of those examples are when the employee intentionally caused their own injuries, or the employee was injured while playing around or while intoxicated. Also, if the employee was injured outside of work or while voluntarily participating in an off-duty sport or social event. Some typical compensability or liability disputes are about course and scope, which means the carrier is disputing if the injury or illness or even fatality was caused by the work activities, or if the injury, illness, or fatality was an exception to liability. This is where the C and the L for CERL come in, when the carrier disputes compensability or liability. It's important for you to know if there's a dispute as soon as you can. Unfortunately, a healthcare provider may not know about disputed CERL issues until after medical services are provided and the medical bill is denied for a CERL reason, or before medical services are provided and a written reauthorization approval includes a notice of unresolved CERL disputes. When an injury happens, the employee should notify the employer no later than the 30th day after the date the injury occurred or after the date the employee found it's an occupational disease. And this is as per the Rule 122.1 of the Texas Administrative Code. As for the employer, once they receive the report of injury from the employee, they must file the employer's first report of injury, which is the form DWC 001, to the insurance carrier within 8 days from the notice of injury, within or within 8 days after the employee absence it's from work, like if they're absent more than 1 day. So after the 8 days, they have to report it, or from receiving the notice of occupational disease. Again, this information can be found in the section 120.2 of the Texas Administrative Code. The insurance carrier's written notice of injury should be done at the earliest of receiving the employer's first report of injury or receiving a notification from the Division of Workers' Compensation or receiving any communication regardless of the source that fairly informed the carrier of the injured employee's name, the employer's name, the approximate date of injury, and information that indicates it's a work-related injury. For example, your medical bill. Please note that as per the Texas Administrative Code Rule 124.1, the carrier must contact the employer within 7 days of receipt of any of these notices. Once the insurance carrier receives the written notice of injury, they must start their investigation to determine compensability of the injury, meaning if it happened during course and scope of the employment. Also, they should determine if they are liable for that injury and if they need to start paying for benefits like temporary income benefits and, of course, medical benefits. If the carrier believes that the injury is not compensable or that they are not liable for that injury, they have to file the notice of denial of compensability, liability, and refusal to pay benefits, which is the plain language notice 01 or PLN1. They must file the denial notice to the division and to the claimant. Keep in mind they don't have to file a notice with the healthcare providers treating not network claims. So it's important that if you are treating for a claim that's non-network, you try and get a copy of that denial. Ask, the injured employee and try to get a copy. However, under Insurance Code 1305.153, for network claims, a healthcare provider will get a denial notice when the carrier disputes compensability and liability. That means that if a PLN1 was filed between the 15th and 60th day after the receipt of the notice of injury, the insurance carrier is liable for medical services provided prior to filing the PLN1. It's important to find the date the PLN1 was filed and get a copy if you can. Keep in mind that the PLN1 is not final adjudication. You or the injured employee should have to go through the dispute resolution process to seek final adjudication. You can present the PLN1 date information during reconsideration or during hearings like a benefit review conference or a contested case hearing. On the network side, as per Insurance Code 1305.153, the carrier shall notify in writing a network provider if the carrier contests the compensability of the injury. So you will get that denial notice for network claims. Now, before the carrier files the notice of denial, the insurance carrier may not deny payment for medically necessary healthcare services based on compensability. Also, the insurance carrier is liable for up to a maximum of $7,000 for medically necessary healthcare services provided prior to the notice of denial. Again, this applies to network claims. Now let's talk about the extent of injury and relatedness. This is the E and the R in the CERL acronym. This is when an insurance carrier looks at the medical documentation and medical bills to review diagnosis codes. They may deny the bill if they see diagnoses that are not accepting as part of the compensable injury, which is the extent of injury. They may deny if the treatment provided to the injured employee is not related to the accepted diagnosis. This is the relatedness part of the CERL disputes. If the insurance carrier is disputing extent of injury or relatedness, they should file a PLN11, which is the notice of disputed issues and refusal to pay benefits. And it should be filed no later than the earlier of the date the insurance carrier denied the medical bill or the due date for the insurance carrier to pay or deny the medical bill. When you get an explanation of benefits due to extent of injury or relatedness, the insurance carrier should have a PLN11 on file. You can ask for a copy of it and ask if there is a PLN11 on file. If there wasn't one on file, that could be a violation on the carrier side. We often get calls stating that the carrier was paying the medical bills and suddenly they stop paying. Remember, this can happen because a PLN11 can be filed at any time during the life of the claim, especially as the carrier received new information about the conditions being treated and the services. So if a designated doctor exam takes place to address the extent of injury, and the designated doctor determines that the conditions previously denied by the insurance carrier are part of the compensable injury, then the insurance carrier must reprocess and pay all medical bills previously denied for reasons inconsistent with the findings of the designated doctor. The insurance carrier has 21 days from the receipt of the designated doctor's report to reprocess those medical bills. This information can be found in the Texas Administrative Code, Rule 127.10. So that means that you shouldn't have to resubmit your medical bills. Again, they have 21 days to reprocess them. Now, how do you avoid a medical bill denial for compensability, extent, relatedness, or liability? Again, some of these denials are unavoidable, but hopefully with these best practices, they can help you know about the denial ahead of time, and that way you can take action. So some of our recommendations as best practices is for you guys to not wait for the injured employee to tell you the treatment is for a workers' compensation claim. Be proactive. Ask every single patient during intake if the treatment they're seeking is for a work-related injury and get that in writing. Documentation is key. It's also great practice to confirm this in the exam room by asking where did this injury occur, or what were you doing when this injury happened. These questions may prompt the patient to confirm that the injury is work related. Once you have confirmed that the injury is work related, ask the injured employee if they have any outstanding disputes on CERL. That's a PLN1 or a PLN11. The injured employee may not know what that means, but you can ask them in a simple or plain language way by asking, has the insurance carrier told you that you're not entitled to workers' compensation benefits? Remember that when the carrier files a PLN, they are required to send a copy directly to the injured employee, and you can ask them for a copy of that denial letter. When an injured employee is being referred to you, ask the referring provider if they are aware of any disputes on CERL. If they are, then ask what conditions have been disputed. Ask for a copy of the PLN1 or PLN11 if they have one. Remember, the carrier doesn't have to send a copy to the providers unless it is a network claim. Ask if they have any medical bills denied for this reason. If they say yes, ask if they have pursued dispute resolution. Again, if the answer is yes, ask what was the final adjudication decision. And if there's a sterile dispute, ask the treating doctor if they will help by providing a causation letter or with participation in dispute resolution. Also, you can ask the adjuster if there are any outstanding CERL disputes on the claim. If they say yes, you can ask for a copy of the PLN1 or PLN11. Keep in mind that the carrier is not required to send a PLN11 or PLN1 to the healthcare provider, except when the claim is in a network and during the pre-authorization process. Remember that an approved pre-authorization just means they cannot deny the bill for medical necessity, but they can deny for CERL later. So read the pre-authorization because the carrier can indicate at the bottom if there's a dispute on compensability, extent of injury, or relatedness. So once you've sent your bill to the insurance carrier and you received an explanation of benefits, you need to be able to identify the reason for denial and if it's a CERL reason. We have a rule that talks about the communication between you, the healthcare providers, and the insurance carriers. This is Rule 133.3 of the Texas Administrative Code. Now here, in this rule, the communication from the carrier to healthcare providers must be sufficient and specific for you to easily identify the reason for denial. This can be made by telephone, electronic transmission, mail, or personal delivery. The carrier must maintain documentation of those communications. The insurance carriers are required by our rules to use standardized coding on the explanation of benefits. These codes are called claim adjustment reason codes, or CARCs. These codes are used when the total paid is not the total amount charged. This is how they explain the adjustment as required by Rule 133.500 and 133.501 of the Texas Administrative Code. This is also indicated in the Texas Administrative Code, Rule 133.240, for medical payments and denials for paper and electronic EOBs. You can find more information about the remittance or card codes in section 133.500 of the Texas Administrative Codes. Also, if you want to read through the codes, they can be found at x12.org. Look for the external code list 139. Remember, these are nationwide utilized codes. They are not specific to Texas. Although the carriers must use these codes on their explanation of benefits, they may supplement with additional information to make the reason for the adjustment sufficient and clear to understand. Here, we listed some claim adjustment reason codes that relate to CERL denials. For instance, code 219 is for extent of injury. Code P2 is for when the carrier disputes the liability of the injury or illness. Again, these are some of the codes that the carrier can use, but they may provide a little more information like the services rendered were not related to the compensable injury. If you call our ComConnection line and tell us that you received a denial, our first question will be, what does the explanation of benefits say? This is to ensure that you take the appropriate dispute path. Here we have an example of an explanation of benefits denial for compensability. They use code P6, which is entitlement to benefits. They are denying the whole claim as not compensable. On the PLN1 that they filed to match that, they explained that it didn't happen during the course and scope of employment, that it is an ordinary disease of life. So it is important to get a copy of that notice if you can. On this explanation of benefits for extent of injury and relatedness, we can see code 246, which says that the treatment for or services have been determined to be unrelated to the extent of injury. And they're also trying to tell you that final adjudication has not taken place. Again, the explanation of benefits is not final adjudication. Final adjudication is a term used for when the Division of Workers' Compensation resolves these disputes. Don't let the insurance carrier mislead you to bill the patient without final adjudication. So this is the matching PLN 11 for that explanation of benefits denial that we just looked at. The box checked indicates that the carrier does not agree that some of the medical conditions were caused by your work-related injury, which is the extent of injury. Then the carrier explains the reason they don't agree. This is why it's important for the doctor and clinical staff to read this information to see what's not being accepted as compensable. It's also important to discuss this with the injured employee to explain if the conditions are work-related or not. If both the doctor and the injured employee believe the extent of injury is part of the compensable injury, the doctor can write a causation letter to help the injured employee go through the dispute process. What's next after a denial for CERL? Well, make sure you do not bill the injured employee unless the denial has gone through the dispute process and the division has issued final adjudication. Final adjudication will be a decision and order from the division where it's indicated if a condition and related services are compensable or not. If you bill the injured employee prior to final adjudication, you could be in violation of the Texas Labor Code section 413.042. Again, the explanation of benefits is not final adjudication. Final adjudication is a decision from the Division of Workers' Compensation that is no longer appealable. So if the appeal timeframe has passed and neither party has appealed, then the decision is final. This final decision is obtained through the Division of Workers' Compensation Benefit Dispute Resolution process. CERL disputes are about compensability, extent of injury, relatedness, or liability, not about reimbursement of medical fees. So for this type of disputes for CERL, you have to develop a position statement with any causation or relatedness information. The doctor's expertise come into play here. We want you to attempt to resolve the issue with the injured employee and insurance carrier by requesting reconsideration within 10 months from the date of service, as outlined in Rule 133.250 of the Texas Administrative Code. Make sure to document this effort. Once you have filed the reconsideration with the carrier, follow the Division of Workers' Compensation Benefit Dispute Resolution process as a subclaimant. The patient is the claimant, and the healthcare providers can dispute as a subclaimant. You'll have to follow important rules on this dispute resolution process, starting with Rule 140.6 of the Texas Administrative Code, which talks about establishing subclaimant status, as well as the rights and procedures. Then on Rule 141.1 of the Texas Administrative Code, you can find the steps for requesting and setting a benefit review conference. You'll need to use the form DWC 045, which is the request for a benefit review conference. You can find this form in our Workers' Compensation A to C under letter F for forms. Make sure you don't use the DWC 45M, which is to appeal a medical fee dispute resolution decision. Again, this one, it's the same number, it just has the letter M as medical. So make sure that you don't use that one for CERL disputes. Okay, so now we'll talk about some helpful resources that we have available. This chart is to help guide you on the correct dispute path. Here we've listed some of the most common denial reasons and the appropriate dispute process to pursue and the form to submit to resolve your disputed issues. You'll want to look at your explanation of benefits, denial reasons to determine which dispute path to take. These can be found on the healthcare provider page under the medical billing and denials tile. We don't want you to waste your time, so knowing where to go next after you have received both initial and reconsideration explanation of benefit denials, that's very important. So remember, most of these processes have deadlines to submit a dispute. So make sure you are pursuing the right process for your type of denial reason, or you could miss your deadline to pursue the correct dispute process. Here you'll find one pager for the steps to take to request a benefit review conference. And let me show you real quick where you can find this on our page, on our website. So if you go to our Texas Department of Insurance website, you'll make sure to click on the top here where it says workers' compensation. Then you scroll towards the center of the page and click on Use Workers' Compensation A to C. Make sure to use this one. Otherwise, if you use the one on the top of the page, that will take you to the main Texas Department of Insurance website. So use Workers' Compensation A to C. First, I'm going to show you like for the letter F for the forms. This is where you can find the forms that you need. If we go back up to Texas Workers' Compensation under the Healthcare Provider tab, you go here to Medical Billing and Denials. And if you click here on Medical Bill and Pre-Authorization Denials, this first, the second bullet point is steps for dispute resolution of a medical bill. This is the chart that I was showing you right now. And then also here you'll find the information for the benefit dispute resolution. Let's review what we talked about today. We discussed the definition of compensability. We reviewed the timeframes to file a notice of injury and how the carrier may dispute or deny after their investigation. We reviewed some best practices to try and avoid CERL denials. We learned to identify medical bill denials for CERL. We also talked about the steps to take to dispute CERL denials. And we went over some resources that we have on our DWC website. Okay, so let's move to our cool down session with a fun challenge. We put together 5 questions based on today's webinar to test how well you've absorbed the material. You'll have a few minutes to tackle these questions and see if I did a good job explaining everything. We'll go through the answers together. Are you ready to flex those muscles? Let's review our questions and see how we did. Let's see here. Question number 1. Is the insurance carrier only responsible for paying for necessary medical service for a compensable injury? And this is true. That's about 80% of you got this correct. So yay, good job. Question 2. Is the insurance carrier liable to pay for some medically necessary services prior to a PLN1 notice of denial of compensability, liability, and refusal to pay benefits is filed? This is true. Again, yeah, the carrier is responsible for those for payment of those services prior to filing the PLN. So good job. Most of you got it correct, so perfect. Question 3, is the insurance carrier responsible for notifying the healthcare provider on a pre-authorization approval letter about any outstanding disputes on extent of injury, relatedness, or compensability? And this is true. Remember, the pre-authorization for medical necessity, they may include there at the bottom if there are any outstanding CERL denials. So yes, it's true. Question 4, if the healthcare provider obtains pre-authorization approval, can the insurance carrier still deny payment for reason of extent of injury? Yes, this is true. Again, pre-authorization is strictly for medically necessary. It doesn't mean that they cannot deny for extent of injury. Question 5. Can a healthcare provider bill the injured employee if they receive an explanation of benefits stating the medical bill is denied for compensability without final adjudication. And this is false. Remember, a denial letter appealing, it does not mean that final adjudication has already been issued. It has to go through the dispute process first in order for the healthcare provider to be able to pursue that reimbursement from the injured employee. Otherwise, you can be in violation of the Texas Labor Code 413.042. Great job, everybody. Um, if you may need to X out of that window, that way it clears from your view. So next time we'll have day 6 of our bootcamp and we'll tackle the cargo net climb. That's where we'll climb to learn to determine the steps needed to participate in a benefit review conference, which is a BRC, and a contested case hearing, which is a CCH. We also will know what to expect and how to prepare for those, and to understand what final adjudication means. If you have any additional questions, you can call our ComConnection line at 1-800-252-7031, option number 3, or you can send us an email with your inquiry at our comconnection@tdi.texas.gov. Thank you so much for watching today.